On October 21, 2010, two men attempted to rob William Glatt's jewelers in northeast Philadelphia. The men entered the store and approached Margaret Colbridge, an employee, and asked her to remove a link from a watch band. They followed her into a back room and one of the men placed a gun to Colbridge's head. Meanwhile, the second man placed a gun to the head of Eric Stice, another employee, and told him to drop what was in his hand. Stice dropped a weapon to the floor. Colbridge then struck one of the men and broke loose. She ran out the front door, yelling for help. The first man told the second man, "Get her. Shoot her." The second man ran out the door, but the woman was already at a nearby pharmacy, and the man got in a car waiting around the corner and left. Inside the store, the first man was still pointing a gun at Stice. Paul Brewington, a salesman, had his hands down and his back turned to show he wasn't a threat. William Glatt, the store's owner, then reached for his gun, and he and the would-be robber fired shots and hit each other. Stice recovered his weapon and also shot the robber. Glatt died at the hospital. He was 67 years old. The robber, later identified as 22-year-old Kevin Turner, died at the store. He had escaped 8 days earlier from Corinth from Hold Correctional Institution, where he was awaiting trial on a weapons charge. The three witnesses inside the store gave similar descriptions of the second man. Each said he was a thin black man in his late teens, standing about 5 feet 8 inches tall. Another witness who had seen the man running from the store also gave a similar description. Police recovered the in-store surveillance video. The footage showed Turner visiting the store on each of the 2 days before the robbery. It also showed the robbery itself and the movements of the two men as they moved about the business. Working from the video, police created a still photo of the second man and released it to the public, where it was shown on TV and published in area newspapers. On October 23, 2010, Rani Shakata called the police and said that she believed the man in the photo was Dante Waters, her son's father. Armed with that information, detectives with the Philadelphia Police Department re-interviewed Colbridge and Stice. Both employees identified Waters as bearing a resemblance to the second man. Waters had a previous robbery conviction and had been sent to jail on October 22, 2010 after violating conditions of parole for an unrelated assault arrest in August 2010. They searched Waters' house on October 24, 2010, and found clothing similar to that worn by the man who ran from the store. The next day, October 25, 2010, detectives received a call from the girlfriend of Donald Cheek, who was in jail in Camden County, New Jersey, after being indicted on federal charges of drug possession and robbery. The girlfriend said Cheek had information about the murder. After getting approval from Cheek's attorney, detectives interviewed Cheek, and on November 4, 2010, Cheek said the man in the photo was 27-year-old OBINA Onyiah, whom he had known since 1997. At the time, Onyiah had a previous federal robbery conviction. Detectives examined Turner's cell phone and call records, looking for any connection between the two men. They found none, but Onyiah became the main suspect, replacing Waters. By now, Detective James Pitts was leading the investigation. On November 8, 2010, police searched Onyiah's last known address, his mother's house. They didn't find anything connecting him to the shooting. His mother said Onyiah had not lived there in months. Detectives also interviewed his sister, Christine Onyiah, and showed her the photo captured from the surveillance video. In his report, Pitts said that Christine identified the man in the photo as her brother. Christine also agreed to help the police, calling her brother and arranging to meet him near a restaurant. When Onyiah showed up, just before 3 p.m., the police took him into custody. While Onyiah waited at the police station, officers searched the house where he was living with his girlfriend, Catherine Cardona. Nothing was found, and Cardona said detectives then took her to the police station, where she sat outside the interrogation room. According to police records, the interview with Onyiah began at 10:50 p.m., more than 7 hours after he was taken into custody. The records said Onyiah was read his rights and then waived them. After being questioned, he signed a statement acknowledging his role in the robbery and murder at the jewelry store. Although all this activity took place on November 8th and the early morning of November 9th, Onyiah wasn't formally arrested until November 10, 2010, charged with second-degree murder, robbery, and numerous firearms violations. Following his arrest, Coleridge, Stice and Brewington went to view a live lineup. Coleridge and Stice picked Onyiah out of the 6 men in the lineup. Brewington said he wasn't sure. Prior to the start of Onyiah's trial in the Philadelphia County Court of Common Pleas, his attorneys moved to suppress his statement to police, arguing that Pitts and other officers had beaten Onyiah while he was in custody. During a hearing on the motion to suppress on May 22, 2013, Cardona testified that she heard Onyiah screaming while the detectives interrogated him. She said she heard loud thumps and 2 men tell Onyiah to stop effing around and tell us the truth. She later heard him tell the police to stop hitting him and that he hadn't done anything wrong. At one point, Cardona said, a detective came out of the interrogation room, sat down next to her and expressed frustration. She said, he's like, man, this is not our guy. Cardona said that when Pitts came out of the interrogation room, she asked him what was happening. He told her to mind her own business. Pitts testified at the suppression hearing. He said that he never touched Onyiah and that Cardona was lying about being at the police station. As proof, he noted that her name wasn't in the homicide unit's log of visitors and witnesses. In addition, prosecutors said that Onyiah's booking photo, taken on November 10th, showed no bruises on his face. Onyiah did not testify at the suppression hearing. He would later say that the detectives beat him on the chest and shoulders to avoid leaving bruises that would be easily noticed by jailers or court officials. Judge Sandy L.V. Bird denied his motion to suppress. The trial began on May 23, 2013. Prior to trial, both sides had stipulated to a police report that said fingerprints found on the jewelry store display case could not be attributed to Onyiah, Turner or a third man, Jamal Hicks, whom police believed was involved in the robbery. At trial, Coleridge and Stice identified Onyiah as the second robber. Brewington, who had failed to make an identification after the live lineup, now also identified Onyiah. He said that he was able to do so after he independently reviewed the videotapes. Jeremy Carrion, Onyiah's parole officer, testified that Onyiah was the same person as in the still photo taken from the video. Cheek also identified Onyiah as the man in the photo. He testified that he had received a favorable sentencing recommendation in exchange for his testimony. Onyiah's mother, Nina Agua, testified that it was a case of mistaken identity. She said her son's nose was longer and his face squarer than the person in the still photo. Cardona testified about what she said she heard when she sat outside the interrogation room. Carter testified for the state. While she didn't retract her initial statement to the police, she said that she had called the police the day after a domestic violence issue between her and Waters, when she was mad at him. Pitts testified first about the investigation itself. He said he had not beaten Onyiah. At the pre-trial hearing, he had testified that he hadn't spoken with Waters prior to dropping him as a suspect. But now Pitts told jurors that he had interviewed Waters at the homicide division and then re-watched the surveillance video before clearing him as a suspect. There was no record of this interview in police reports. Central to Onyiah's defense was a key fact. He was 6 feet 3 inches tall, and the eyewitnesses had all said the second robber was about 5 feet 8 inches tall. That approximate height had even been included in the police department media release that included the still photo. Pitts testified that the release had been wrong and that the eyewitnesses had been mistaken about the second robber's height. He did not say how the police arrived at this conclusion. Detective Torsten Lukey testified about the video footage and said that the two robbers in the video were about the same height. Turner was 6 feet 1 inch. He said, "My personal opinion is that the height of the two would be close to each other because, again, we're looking at it from an angle from above and the second person appears to be several feet behind the first person, and therefore, you would see more of him than the person that's closer to the camera." During cross-examination, Onyiah's attorneys attempted to show Lukey lacked the skill to testify about the heights of the suspects. Lukey said he wasn't testifying about how tall a person was, but rather the relative size between people in the video. But he said such an analysis was possible. "There is a way," Lukey said. "It's beyond my expertise to give you a height for either, other than to point out a difference between the two." He continued, "In order to determine height from a video, and again, I am not an expert in that, I have seen it done and I know a little bit about it, it all has to do with the resolution, the angles of the camera in reference so that you can it helps to have a fixed object in order to determine a moving person's height." Lukey also said that he had not consulted with any experts to do this work. He testified that the process was very elaborate and that he had only used these experts twice in 6 years. Onyiah's attorneys didn't present any expert testimony of their own on height comparisons based on the video footage. At the conclusion of the trial, the court read a jury instruction on expert witnesses, thus implying that Lukey had been an expert, not a lay witness. The jury convicted Onyiah on May 31, 2013 of second-degree murder, 3 counts of robbery, conspiracy to commit robbery, and a violation of the Uniform Firearms Act. He was sentenced to life in prison without parole. Separately, Onyiah pled guilty to an unrelated 2009 robbery on December 9, 2014, and was sentenced on February 27, 2015 to between 8 and 20 years in prison, to run concurrently with his life sentence. On October 13, 2017, Onyiah's appellate attorney, Terry Heinbaugh, filed a motion for post-conviction relief. The motion said that Onyiah's trial attorneys had provided ineffective representation. First, they had not let Onyiah testify at the suppression hearing, which would have corroborated Cardona's testimony that Onyiah was beaten before he gave a statement. While Onyiah didn't testify at the trial, in part because his previous federal robbery conviction could have been introduced to jurors, no such danger existed at the suppression hearing. Second, the motion said the attorneys had not vigorously cross-examined Pitts and forced him to explain how Waters had been eliminated as a suspect. Third, the motion said the attorneys had failed to adequately challenge or exclude Lukey's testimony, which buttressed the state's case that Onyiah was the other robber in the surveillance video. Prosecutors presented Lukey as a lay witness, but Heinbaugh said Lukey impermissibly testified as an unqualified expert witness, and his testimony went far beyond his perception of events and relied on technical and scientific expertise that Lukey acknowledged he lacked. Separately, since Onyiah's conviction, additional information had emerged about Pitts and his interrogation tactics. In June 2017, Judge M. Teresa Sarmina held a 4-day hearing based on a petition filed by attorneys for Dwayne Thorpe, who claimed that Pitts had threatened a witness in order to secure his testimony against Thorpe in a murder trial. At the hearing, 10 witnesses detailed how Pitts extracted false statements from them. Thorpe's motion was granted, and he was exonerated in 2019. Pitts's misconduct was also a factor in the exoneration of Hassan Bennett. This history from Thorpe's hearing was included in Onyiah's motion, which said this pattern supported Onyiah's claim that he was beaten while in custody. Before Onyiah's motion was heard, the Conviction Integrity Unit, CIU, of the District Attorney's Office, DAO, of Philadelphia County began its own investigation into the case, including a new examination of the surveillance video. By now, the jewelry store was closed, making it impossible for a measurement of fixed items, such as door frames. The CIU hired George Race, a forensic video analyst based in California. He analyzed still shots of the video, using the known heights of people in the frames, such as Turner and the employees, as well as reference points such as the display cases. He concluded that the second suspect was no taller than 5 feet 11 inches, including his hat. Race recommended that a second analyst independently examine this evidence. Scott Kuntz, a forensic analyst in Wisconsin, examined the footage. He reached the same conclusion as Race. These findings were presented in the state's answer to Onyiah's motion as well as a joint stipulation by the CIU and Heinbaugh. Neither document addressed the issue of ineffective assistance of counsel, but the stipulation said the evidence showed Onyiah was innocent of this robbery. Onyiah is 6 feet 3 inches, so the video analysis has conclusively excluded Onyiah as the thin black male seen in the surveillance video, the stipulation said. In other words, Onyiah is at least 4 inches taller than the second suspect, the thin black male seen in the video. The responses also said that Pitts's history of misconduct, including 3 documented incidents prior to Onyiah's conviction, were not disclosed. The CIU said there is no evidence that prosecutors knew about this misconduct. Disclosure wasn't the practice at the time. As part of its investigation of this case as well as its investigation into other cases involving Detective Pitts, the joint stipulation said, the CIU discovered that the DAO had a general policy where it not only did not obtain and disclose such records to defense counsel, it notified defense counsel of said policy and advised defense counsel that they should subpoena such records themselves. On May 4, 2021, Judge Tracy Brandis Roman granted Onyiah's motion to vacate his conviction and then approved the dismissal of the charges. Onyiah remains in prison on the unrelated robbery conviction. The violations that occurred during the original investigation and trial led to the conviction of the wrong man, while the individual actually responsible for William Glatz's murder has evaded accountability, said CIU Supervisor Patricia Cummings. The integrity of our criminal legal system demands accountability from all actors, most especially from those with the power and authority to deprive people of their freedom, whether that be for days at a time during an interrogation, months following an arrest, and for decades after a conviction. Pitts was arrested on March 3, 2022, and charged with 2 counts of perjury and 3 counts of obstruction.
Thank you all for being here. We have organized this press availability with reference to the arrest and criminal charging of Philadelphia Police Department Homicide Detective James Pitts for his role in the 2013 wrongful murder conviction of a man named OBINA Onyiah. A little background. What I'm holding here is a presentment. Presentment is the official document of a grand jury, and in this case, the presentment I'm holding was unsealed today by the Court of Common Pleas after some good and diligent work, not only by the 31st Philadelphia County Investigating Grand Jury, but by some of the people who are here with me with reference to this case. Let me acknowledge them. So in addition to having with us First Assistant Carolyn Engle-Temmett, the Honorable Carolyn Engle-Temmett, we have with us First Assistant Bob Listenby and the Interim Chief of the Conviction Integrity Unit, Michael Garmisa, who was primarily responsible for this outcome, and also with him Rebecca McDonald, Assistant District Attorney Rebecca McDonald, who is in our Conviction Integrity Unit and works on this particular matter. What the presentment says, I will just state briefly, and then we'll hear more details from Mr. Garmisa, who primarily handled it. But what it says is that Detective Pitts is to be charged with 2 counts of perjury, which is a 3rd-degree felony, and 3 counts of obstructing the administration of law, a 2nd-degree misdemeanor, for allegedly lying. And what was he lying about? He was lying about his own violent interrogation of a man named OBINA ONYIAH in 2010. He was lying in his false trial testimony about that same homicide matter in 2013. OBINA ONYIAH, that name may ring a bell for some of you, because on May the 4th of 2021, the Court of Common Pleas vacated ONYIAH's murder conviction and dismissed all charges against him after Mr. ONYIAH spent 11 years in jail. This is a case in which the DA's Conviction Integrity Unit exonerated OBINA ONYIAH, who is likely innocent of all the charges that were brought against him. OBINA ONYIAH was the 20th individual exonerated by the Conviction Integrity Unit. There have been a total of 24 exonerations since 2018. The vast majority resulted from wrongful homicide convictions, and those convictions were originally obtained under former DA Lynn Abraham, followed by former DA Seth Williams. There are a lot of very interesting and very troubling details about this matter. Copies of the presentment are available, and the press release alone comprises more than 3 pages. But I believe the person most qualified to speak about the details here is Mike Garmisa, who's doing a fabulous job as our Interim Chief of the Conviction Integrity Unit and continuing the remarkable achievements that the unit had under its prior leadership, namely Patricia Cummings. But I think he is best placed to address all the details here and also to observe the line about what we can say and what we cannot say at this time, what would be appropriate. Once he has concluded, we will be available for questions. Mr. Garmisa.
So the presentment is a document by the grand jury that was voted on that recommends charges, and they are allegations, and this defendant, like all defendants, are presumed innocent. The allegations in this presentment allege that Detective James Pitts, who was then assigned to the homicide unit of the Philadelphia Police Department, conducted an interrogation into a murder that occurred at the Black's Jewelry Store in 2010 that was a murder that garnered a lot of press attention because the owner of the store, who had been a small business owner in the community for many, many years, was killed, and one of the perpetrators was killed during a shootout. The second assailant escaped, and as a result of that, there was an investigation. ONYIAH was convicted primarily on the testimony of confession that we now know to be false, that he gave to Detective Pitts, and the grand jury presentment describes the physical assault that ONYIAH had consistently claimed occurred and was the result of what resulted in his false confession. We were able to determine, and this grand jury found that based on photogrammetry analysis, which is height comparison from video, that ONYIAH was likely innocent, could not have been the perpetrator because he is 6'3", and the assailant who escaped was at most 5'11". The grand jury recommended charges related to the conduct in the interrogation room, punching with closed fist, poking, or how Mr. Onyiah described it, is doinking him in the chest, and grabbing him by the neck and forcing his head down between his legs. Detective Pitts is also charged with perjury for lying about those physically coercive interrogation tactics when he testified at a pretrial motion to suppress, when Onyiah claimed that his confession was the result of physical coercion, and also for false testimony at the jury trial where Onyiah claimed that his confession had been physically coerced. Are there any questions? Detective Pitts joined the Philadelphia Police Department in 1996. So there have been a number of litigants making those claims, and we're going to review them on a case-by-case basis. There have already been some convictions that were vacated, most notably the Honorable Teresa Sarmina vacated the conviction of Dwayne Thor in 2017.
If there are no other questions, I guess I just have a final comment. As someone who started in the criminal justice system in Philadelphia as a lawyer in 1987, I went through one administration after another in the district attorney's office where, frankly, certain kinds of illegal, violent, coercive conduct, followed by lying about it, were okay with the prosecutors I used to see, not all of them, some of them. I cannot calculate the enormous damage that was done to a public sense of trust in law enforcement by those kinds of tactics. I remember when the Honorable Teresa Sarmina in 2017 did something that we all saw as being not only legally correct but courageous in the Thorpe case. For those of you who don't remember, she actually looked at the fact that there were so many incidents in which the same kinds of allegations were made involving the conduct of Detective Pitts, conduct about which there had been rumors in the courthouse for years. That's how she came to her conclusion in Thorpe. Well, I am happy to tell you that that is not the culture of this office. That will never be the culture of this office. And that we believe that every time we get to the truth, we get away from the lies, we admit wrongs that were done in the past by this institution and by other institutions in the city, then we increase that trust. And as we increase that trust in the community, we will have more victims come forward. We will have more witnesses cooperate. We will have more juries whose minds are open, that we are presenting the evidence, we are presenting the truth, and we are doing so fairly. That is only one of the reasons why this is so important. But kudos to Mr. Gormisa, to Rebecca McDonald, to the work of the CIU, to everyone who all along all these years said something was wrong, because something was really wrong. And I'm delighted to see that a Philadelphia jury is going to have a chance to make a decision about whether or not we are correct. Thank you very much.